How's it looking so far?
Good. We'll just give it a couple more seconds for people to join.
Yeah, absolutely.
Did you see that Peter Norlander is there?
Cool. I haven't seen Peter in a while.
Oh, good. We're actually thinking of working. We're talking to Peter about doing a report on slaps at CIMA with him.
Good person to do that. Yeah.
Seems to be the right guy. Absolutely.
Hello, everyone. It seems like lots of people have trickled in, so I think we are able to get started. Thank you, everybody, for joining. My name is Andrea Vega Utica. I'm an assistant program officer here at the Center for International Media Assistance. We are a think tank dedicated to media development and media freedom issues housed at the National Endowment for Democracy. And it's my pleasure to welcome you to our first virtual event of the year, Breaking the Silence, Countering the Effect of Slaps on Independent Media. Research has shown that strategic lawsuits against public participation, commonly known as slaps, and a term that we'll be mentioning a lot this morning, continue to be an effective intimidation tool to silence journalists. These lawsuits succeed in crippling news outlets with legal fees, even when based on frivolous accusations. So we hope this panel will help shed more light on the nature of these vexatious lawsuits and what might need to be done to mitigate the spread of legal abuse. We hope this conversation also will be engaging for all of you today. So we encourage you to use the Zoom Q&A feature down below so we can incorporate your thoughts and comments for the question and answer portion of our session. Today's conversation will be moderated by Nick Benequista, CIMA Senior Director. Nick draws from an extensive experience in international media development, applied research, democracy support, and journalism. He's been a foreign correspondent in Latin America and has overseen policy-oriented research projects around the world with UK's Institute of Development Studies and Canada's International Development Research Centre. So without further ado, Nick, up to you.
Thanks very much, Andrea. Thanks for bringing all of us together today. And thanks to all of you for joining us. We know that time is a precious commodity these days, and for many of you also counted in billable hours. So we appreciate your presence. As Andrea mentioned, a strategic lawsuit against public participation is a lawsuit that targets forms of free speech. It often threatens to bankrupt the defendant and is often wielded in a way to remain in court as long as possible, aiming to weaponize judicial proceedings themselves. The Maltese investigative journalist Daphne Caruana Galicia, as you all know, was assassinated in 2017. At the time of her death, she had 42 civil libel suits against her, many of which had frozen her personal assets. And these were brought against her by Maltese politicians and their business associates, many of whom she had been investigating. So that revelation really was a spark to bring new attention to slaps. The discussion of what is or is not a slap can get a little semantic. And today, to be sure, we are going to talk also about long-standing threats to free speech that sometimes get overshadowed in the slap discussion. But here's what we know. Across Europe, the number of slaps has skyrocketed. 4 slap cases in Europe in 2010, 114 in 2020. This is according to the Coalition Against Slaps in Europe. We know that slaps, and we'll hear about that in detail today, are a special threat to cross-border investigative journalism, the kind that tries to hold to account global networks of corruption and authoritarianism. These global networks of corruption and authoritarianism have been described by Anne Applebaum as authoritarianism, Inc. And so what we know is that the rise and growth of these kleptocratic networks, the growth, on the other hand, of cross-border investigative journalism networks like OCCRP, CLIP, the International Consortium of Investigative Journalists, and the rise of slaps, these things are really intertwined, and how we navigate this moment will have a huge influence on which side prevails. So we'll be describing the problem of slaps today, but also looking to our esteemed panelists to some of the strategies and responses that are emerging to defend journalists against this growing threat. We have four really excellent panelists today. We have Drew Sullivan, the co-founder and editor of the Organized Crime and Corruption Reporting Project, an investigative reporting platform for a global network of independent media centers and journalists. We have Susan Kotry, who joins us from the Foreign Policy Center and International Affairs think tank, where she leads the Unsafe for Scrutiny project, examining issues at the nexus of safety of journalists and anti-corruption in the UK. She also co-chairs the UK Anti-SLAPP Coalition. And we have Alex Papachristou, the executive director of the Cyrus R. Vance Center for International Justice, where he leads the Good Governance Program, providing pro bono legal representation to anti-corruption and investigative journalism organizations worldwide, including the OCCRP. And Sarah Saenz, who is the project manager and a journalist at Ojo Publico, which is a leading investigative news outlet in Peru, doing excellent work to promote national and regional investigative journalism and reporting the abuses of power and human rights violations. Ojo Publico, as we'll hear, has been sued for defamation multiple times and confronts many burdensome costs on these kinds of legal matters. Thanks for joining us, everybody. I'd like to start with Drew. So the OCCRP has been the subject of several slaps. Your co-founder, Paul Radu, worked on a recent investigation titled The Azerbaijani Laundromat, exposing a money laundering operation that made him the subject of a slap in the UK, which is in many ways a textbook example of a slap. So Drew, could you walk us through a little bit what transpired with that case and how OCCRP responded?
Yeah, sure. So that was a case where we were pretty much slap silly. It was as you mentioned, the Azerbaijani laundromat, and we were sued by an Azerbaijani businessman who had worked at he was the director of a pharmaceutical company in Azerbaijan that had received large amounts of money through this Azerbaijani laundromat. What looked to us like trade-based money laundering. His business partner, his longtime business partner, was also very close to the Pashiyeva family, which had an ownership. Pashiyeva family is the family of the first lady of Azerbaijan, Mehraban. And so it was very clearly connected to the highest levels of the government. And it was interesting, they sued us, they sued our Romanian branch, which is more of a technical company within OCCRP. It doesn't do any of the journalism. And they sued Paul Radu, who is one of our co-founders with me, but they sued him not on the story, but based on a tweet that he had made, retweeting an OCCRP tweet. And this was done probably for jurisdictional reasons. Paul had coordinated the Azerbaijani laundromat, but he had no play in this particular story. In fact, I was the editor, he was not the editor. He had no say whatsoever in the story. So a company that doesn't do journalism was sued with a person who had nothing to do with the story based on a tweet. So it was an unusual case. We tried to get it thrown out court in the UK, but the court ruled that this whole issue of jurisdiction and appropriateness of the person would not be dealt with until the whole case was dealt with, which would mean after discovery and after filings, multiple filings, and a couple £100,000, maybe even close to £1 million would be spent before we could even get to court to consider this issue that maybe they sued the wrong person and the wrong company. And so consequently, I think they later dropped the Romanian branch from the suit, but they continued to sue Paul. And that's one of the problems with the UK system is every case gets heard. Almost every case that there is some kind of, potential, libel or defaming will get heard by the court, which means you're immediately into, a big amount of money. And for instance, Paul had to have every one of his computers, every one of his phones searched by a person who flew to the Caribbean where he was teaching classes, broke into all his systems. Paul had to give all his passwords. spent about $40,000 doing discovery on our systems. When we would appear, as we were getting close to appearing in court, the other side gave us one document as part of their discovery process, one single document. So it was you know, we wondered whether they had any hope of ever winning this case in the first place. The other problem with the British system is it also said that you know, it makes a determination of meaning of a story, which may have nothing to do with the actual story. You know, we never mentioned that this person was laundering money. We simply indicated what flows of money there were. But the UK system said, well, in fact, you were saying that he was laundering money, and therefore you must prove in court that he was laundering money, even though he never said that. So our real approach to this was to not stop reporting. So as soon as we were sued, we continued to work on the case quite aggressively. By the time we were filing our final submittals to the court, not only were we saying that he was laundering money, we were saying a lot more than that. We were saying he was involved in a criminal conspiracy. We were going way, way beyond the story, which is quite unusual. But you know, we just felt we had to keep doing this. It cost us a tremendous amount of time. It cost us a tremendous amount of travel. It cost us a lot of money in discovery. And so we were in for, you know, somewhere in the $500,000 range before the case even opened. But possibly because of these filings, the case was settled at the very last minute in a manner in which we found quite favorable. And so we were quite tickled pink that we wouldn't have to go in a course. And I can't say what the settlement was, but let's just say that you know, it solved all of our problems. But this was an unusual case. It took great lawyers that we had to understand a very sophisticated money laundering operation, which most lawyers probably wouldn't understand, and which most courts would have difficulty understanding. You know, an elaborate trade-based offshore multi-jurisdictional money laundering system is very complex, and a good lawyer on the other side can make it quite complex, understanding, you know, seeing it from a different perspective. So, you know, in the end, it worked out for us, but, you know, we were lucky we had great lawyers, thanks to Alex, who's going to speak later. He arranged the support, the pro bono support for us during this whole process. But other people would not be in the same situation, and they wouldn't have had the resources that we had to continue reporting on this. So we dodged a bullet, but you know, we were lucky, and a lot of other people I don't think would have been.
Thanks very much, Drew. Just as a quick follow-up, you know, do you, if I could ask you to speculate a little bit, do you believe that the continued investigations that the OCCRP did helped to persuade the other side to provide a favorable settlement?
We screwed him to the floor. I mean, he was, I do, yes.
But it's great. It's great that you guys were able to do that. That's great. I mean, not many organizations have the kinds of resources to be able to punch back as the OCCRP can, though. Thanks very much.
You can't find that information because, you know, it was all offshore. We were quite lucky that even in that, you know, we had gotten a lot of leaks and we'd gotten a lot of information, and you know, so we were able to break that veil. But a lot of people would, you know, it could be set up where you couldn't do that.
Thanks, Drew. Susan, turning to you, Drew alluded to the fact that the UK is among the jurisdictions that have become attractive for the filing of these slaps. Could you say a few words about why the UK has become a kind of advantageous jurisdiction for, you know, libel tourism, as they describe it, and what you and your allies are doing to make it a little less hospitable for these kinds of shenanigans?
Sure, thanks, Nick. I mean, as Drew's just alluded to, the cost and the length of the proceedings in the UK are probably the biggest factors that make it a pretty attractive jurisdiction to bring a claim if you're a claimant, because the burden of proof is also on the defendant. And as Drew also mentioned, we have a system here where the judge decides the meaning that you have to defend, which is a single meaning. And so that cannot necessarily be what you thought you meant when you were writing it or saying it in some case, and it affects your defense as well here. So if you're using the truth defense, then and the judge decides that, you know, perhaps you meant something else and you thought that you meant, you can run into a challenge, which is kind of what Carol Cadwallader, who's another journalist currently being sued. They just had the trial in January, but the judgment's pending. She was being sued by Aaron Banks. And so, you know, who was involved in the Leave campaign here in the UK. I mean, we started the Unsafe for Scrutiny project about 6 months after the conclusion of Paul and OCCRP's trial in the UK, or the settlement. But actually the inspiration for the project had come from previous work that I did at Article 19 when I was supporting journalists who were facing a wide variety of violations for work they were doing, writing about corruption. So in particular, Khadija Ismailova, who's Drew's colleague at OCCRP, who was contributing to the Azerbaijan laundromat from Azerbaijan, and she faced a whole gamut over the last 10 years of smear campaigns, harassment, arrestment, and ultimately imprisonment. And so, you know, the link with the UK was very interesting to us, and we wanted to better understand, you know, the risks and threats. And we actually, the first thing we did was a survey, also in collaboration with OCCRP and other journalist networks. And we had responses from 63 investigative journalists working on financial crime and corruption in 41 countries. And while we were asking them about all kinds of risks and threats, they, more than 70% of the respondents said that they had received threatening legal communication. And it was the greatest challenge for them to overcome, to be able to continue reporting. And that's, I guess, because of the, you know, the insecurity it can create financially, it's the financial sustainability. But the really alarming thing for us was the fact that the UK was the international leading source of those threats. More so, or sort of almost about the same as EU countries and the US combined. So that was a really big flag for us. And in the beginning of last year, myself and colleague from Index on Censorship started the UK Anti-SLAPP Coalition. We're now about 30 organizations. Alex is a member. And we've been trying to work on initiatives to push back against SLAPPs in the UK. We published a policy paper in July, and then we were working with some media lawyers to look at what kind of sort of legislative and regulatory changes we could make here, and putting proposals forward to the government. And I'm pretty pleased to say that we've had a sort of step forward here last week with the announcement that Dominic Raab made last Thursday. He's launched a public consultation on government proposals, potential proposals, and a call for evidence. So this doesn't mean they necessarily will legislate, but it's a pretty big step forward towards realizing some kind of anti-SLAPP measures here in the UK. And the consultation is open until the 19th of May. If anyone here has been, you know, in the audience subject to a SLAPP or SLAPP threats, then please do look at that consultation. We need as much evidence as possible of the problem in order to really make sure that those who are looking at proposals understand the depth of it and are able to provide effective and robust, you know, mechanisms. I mean, there are already initiatives underway in other places on SLAPPs. I mean, there's some US states that have anti-SLAPP laws, and I'm sure Alex could also speak about the work that's happening in Europe, looking at an EU directive. But there's definitely kind of commonalities of measures, which is trying to dispose of a SLAPP threat as quickly as possible, a SLAPP case. So early dismissal mechanisms, cost capping, trying to make sure, you know, you don't end up having these spiraling costs that Drew was talking about. And sort of creating penalties for those that bring these kind of cases. So to stop the, you know, to act as a deterrent, basically. But of course, I mean, these are all cases that reach the court level. And what we've seen in our research is that it's a bit of a tip of the iceberg, those cases that get that far. And we're quite worried about the fact that there's this kind of hidden level of legal intimidation that's happening with particularly UK law firms that are very specialized in this, that send out quite threatening legal letters to journalists, not just in the UK, but all over the world. And because of the high kind of cost and the amount of time and resource that Drew was also alluding to, that these can be resulting in journalists to take information down and to self-censor, which can create a kind of vacuum of information, which is very concerning when it comes to wrongdoing and criminality. And just to kind of end on the fact that the case that Drew was talking about, the Azerbaijani laundromat and the sitting Azerbaijani MP who sued in London. And London, I mean, another reason is because a lot of the dirty money ends up here, and these people are able to sort of establish a reputation and a link with the UK because they are buying property and setting up companies and sending their kids here to school. But our National Crime Agency just won a case to seize 5.5 million from that MP's family 2 years after the settlement with RADO and OCPC. And imagine if that hadn't happened, so huge thanks to OCCRP and others, not only for doing the initial reporting, but not giving in. But it's a shame that it takes so long for the authorities to act. Journalists are really at the front line, but I'll leave it there.
Thanks very much, Susan. That's that's really helpful. And I think hearing the work that's being done in the UK after understanding how OCCRP was attacked using these devices, it makes it clear that an early dismissal mechanism through an anti-SLAPP law, one that shifts the burden of proof to the plaintiff, that creates penalties to deter these kinds of lawsuits, that would have been really helpful, perhaps, in preventing the lawsuit against OCCRP, which Drew mentioned, could have incurred millions of pounds even before it went to court. So even a frivolous lawsuit in these kinds of systems can have a massively stifling, if not bankrupting, effect on the journalist. That's terrific, Susan. Thanks. I just wanted to, as we, going back to something we mentioned at the beginning of the conversation, these SLAPPs are a growing threat that absolutely needs our attention in the context of these international networks of kleptocracy. At the same time, let's not forget that 160 countries around the world still have criminal defamation laws. So we've been talking about civil lawsuits up until now, but criminal defamation laws still remain a really important way of stifling freedom of expression. Also, over the past couple of years, according to UNESCO data, 57 laws and regulations across 44 countries were adopted or amended since 2016 with overly vague language or disproportionate punishments that threaten freedom of expression and press freedom. These are under the guise of things like hate speech laws or cybercrime laws or supposed quote unquote fake news laws. So there are some new weapons in the arsenal as well. Sarah, turning to you, Ojo Público is another organization that, because of the nature of its reporting, cross-border, focused on corruption and drug trafficking, you have been really vulnerable to vexatious lawsuits seeking to silence your reporting, even when they're groundless. So could you tell us a little bit about the kinds of lawsuits that Ojo Público has faced, the costs that this has created for your organization, and what you guys have learned about how to protect yourselves and your journalists from these legal attacks?
Thank you, Nick. Since its foundation in 2014, Ojo Público has received about 68 notarial letters. This type of letters, according to the Peruvian legislation, is part of the stage prior to the allegedly affected person decide to sue us. Each letter, if it's not well answered, is a potential lawsuit. We have gone through 5 lawsuits for defamation against Ojo Público and our executive director, Oscar Castilla, by an internationally investigated drug trafficker in Peru and USA for $310 million. In February, the Peruvian justice system definitely filed the last defamation complaint sued by the Peruvian American citizen Miguel Arevalo Ramirez, known as ETECO. These were presented after we reported on Arevalo's background in the public ministry, the anti-drug police, and the DEA agency for alleged drug trafficking. Since 2017, Arevalo filed a series of complaints in 4 different criminal courts in Lima against Oscar Castilla and Ojo Público. Currently, we have a fiscal investigation against Ojo Público for improper disclosure of an immunized witness in the Lavallato case, with a request to lift the secrecy of the communications. Now, in October 2021, the journalist Ernesto Cabral was notified by the prosecutor's office for allegedly having incurred in improper disclosure, a crime in Peru that carries penalties up to 6 years in prison. From the 68 notarial letters that we have received since our foundation, 4 became criminal proceedings with the risks up to 6 years in prison, and a request for seizure of assets involved. 1 with the risk of seizure of our laptops for containing information from Panama Papers. 1 under pressure to reveal our journalistic sources, and 3 to remove reports from the internet under the so-called right to be forgotten or misuse of personal data protection law. As we can see, around the 13% of the notarial letters that reach us become potential attacks of freedom of information. No? The entire judicial issue will have cost us approximately $10,000 a month between consultancies paid with our own funds, with funds from organizations such as Media Defense and the Committee to Protect Journalists, and discounts offers by NGOs specialized in freedom of expression issues. Media donors do not necessarily allocate a percentage to cover legal expenses. No? In our case, we must establish a percentage for own funds. However, NET promote a percentage with Ojo Público to pay a legal advisor for journalistic issues in one of our grants for all these cases that we have shared. About time, a criminal trial requires at least 1 month's attention. However, if the case is serious and includes some risk to the patrimony of the journalist or the organization or the conviction, then it takes up a lot of mental time that there is no way to count, that it can be finally expressed in prior censorship of the same journalist and fear of tackling a similar case again, to fear for an uncertain future of losing the case. And what have we learned about how to protect ourselves? The investigative journalist should always look for a legal ally, a reputable law firm without a conflict of interest, and no government or a non-government entity specialized in press freedom litigation to accompany them in the process. And especially, we think that the media must stay united, no? To decisively confront the plaintiff for encourage the journalistic union and the organization that defend issues of freedom of expression at the national level, and if it's possible at the continental level, to join a campaign to the dissemination of judicial abuses, and of course, in some kind of coordinated investigative blog. We think that the enemy of press freedom must feel that attacking a media outlet or an independent journalist is attacking everyone, and that an action of this type will always have a cost for him in the short or long term.
Sarah, thanks very much for that. Astounding to learn that your legal costs amount at times to $10,000 a month, not to include and not to mention the mental costs that the journalists expend worrying about their lives and their well-being. Thanks very much. This is a great seg to Alex, actually, because Alex at the Vance Center has been looking for creative ways to help organizations like Ojo Público to cover their costs. Alex, turning to you, you've got a new project. You want to tell us a little bit about how you guys are thinking about innovation in this area of defense for journalists?
Sure thing. Thanks very much. Good to see everybody. first, I just would echo Sarah in terms of her description of how much broader and how much broader and more threatening scenarios can be. And we've worked with clients in Mexico and Central America recently, facing laws that restrict foreign funding, facing investigations for tax violations. The governments that seek to suppress freedom of press find innovative ways. And we see lawsuits not only in London, but also elsewhere in Europe and other countries as well. So it is a global problem with many facets, and it does require innovation in response, as well as collaboration. I think a key feature is for journalists to support each other, to publicize each other's successes and threats. And it's not just about lawsuits. In the UK, a lot of it happens way before it gets to court and may never get to court. It happens when the lawyers representing oligarchs, kleptocrats, questionable corporations send threatening letters to journalists. And these letters can, just by themselves, intimidate and stop the journalists from reporting. The letters are ominous, they're dire, they're overblown, but they work. So we need to attend not just to the lawsuits, but to the other mechanisms used to intimidate journalists. And it's really sharing information and supporting each other that is the first line of response. But Drew at OCCRP now for several years has urged us on, and we've worked together to develop a defamation defense insurance program for journalists and frankly, all reporters around the world. Early on, Peter Norlander, who I see in the audience, hello, Peter, was an instigator of this effort. And many others have contributed. We've been fortunate to get some pro bono support from AIG, the insurance company, and from my friend Bob Cusimano, who is an insurance law expert. And we've actually come quite a long way. We've recently completed an actuarial survey, which in insurance lingo, and I'm no expert in it, so forgive me, those of you who speak insurance, if I get it wrong. But the actuarial survey, based on questionnaires of media organizations, has enabled the actuarials to determine the likely defense costs that a media organization might incur across a range of scenarios. And what this then will enable us to do is to develop an insurance product, an insurance policy that reporters and journalists can buy. Now, obviously, we're going to try to make it as inexpensive as possible. This is all done on a nonprofit basis, but we do need to build an insurance business that will be self-sustaining. We do look forward to philanthropic support from governments or foundations to get it going and maybe to keep it going, but we do want to build it so that it is largely self-sustaining the way an insurance business is. You have to assess the risk in any particular case, but also across a full range of your policy holders. And then you have to stick to certain protocols and rules and manage a business. Now, a few features of this that are really important. Will be insurance only for the costs of defending a defamation case, or maybe related cases, invasion of privacy, that sort of thing. The insurance will not cover any liability that a journalism organization actually incurs in a court case. Now that seems initially to be wrong. You want to protect them from the liability. However, two things. First of all, it's potentially much too expensive to cover the liability. And also uncertain. You don't know what the liability is going to be. You can survey and analyze the cost of defense from experience, but liability is more wide-ranging. But more importantly than that, if you give people insurance for liability, you invite the bad guys to sue them, because the bad guys know, oh, they have insurance, so if I win, I get the money. You don't want to encourage them. If you insure for defense, then the bad guys say, well, I'm not going to really achieve my goal of harassing and intimidating and distracting, because they have lawyers who are going to defend them. So they can go on doing their journalism and their lawyers will defend them. And I'm not going to achieve my purpose of harassment or intimidation. So the insurance provides coverage for defense. We count also on lawyers being willing to take on defense of journalists, either on a pro bono basis or what we call now a low bono basis. And in the OCCRP litigation, we heard about, we had a combination of pro bono and low bono, and that was secured OCCRP terrific defense in that case. And so we're pursuing similar cases in London and elsewhere in Europe now in that same way. So we have the experience that lawyers will step up to defending journalists sued in these types of slap cases, where the claimant or the plaintiff is clearly not out to save a reputation, because that reputation doesn't exist in the first place. These are criminals, oligarchs, kleptocrats, sketchy companies. They're not interested in preserving their reputation. They're trying to hurt the journalists, and the lawyers will step up to that. And so we hope that really within the next year or so, this insurance program will be up and running, and reporters and journalists will have an opportunity to buy a policy and know that if they get sued or even threatened with a suit, they can have lawyers to defend them. And the more people, the more reporters and journalists who sign up, the better it's going to work, the cheaper it will be. So when the time comes, I hope everybody here shouts out to all of the journalists and reporters you know, if you aren't those yourself, to get this insurance. I never thought I'd be an insurance salesman, Nick, but here I am.
That was a great pitch. I mean, that's the best insurance pitch I've ever heard, actually, Alex. You're doing very well.
You can be policyholder number one.
Thanks very much. Look, that's really exciting. And, we'll without a doubt continue to track the development of this insurance scheme, and we'll really gladly help to publicize it among NED grantees and CIMA's networks, Alex. So congrats on that. For those in the audience, please start sharing your questions. We're going to open it up to you. You'll see in the chat box, you can ask your questions or make a brief comment, and my colleague Andrea Vega will be curating those for the panelists in a moment. I just want to take a quick moment to kind of recap where I think we've gotten to in the conversation and give the panelists one last chance to jump in before we turn to your questions and comments. At CIMA, we love seeing support for independent media. As you guys know, freedoms have been on the decline since 2012, and media viability is really rocky, especially in emerging markets. We need donor assistance, but we see time and time again, international donors coming in saying, hey, please cover corruption, but ignoring the fact that criminal defamation laws remain on the books, that these kinds of lawsuits in response to investigative and public interest journalism can cost these institutions and organizations way more than the value of those grants. So if we're not shifting the enabling environment for press freedom, we're really asking too much of organizations like Ojo Publico and OCCRP to bear the burden of the backlash to their reporting. We've got to really move the needle on that enabling environment. So how do we do that? I think today we've highlighted that we need journalists to report on these lawsuits. Frequently that doesn't happen enough. That allows for public awareness campaigns and perhaps even some naming and shaming. We need to be louder about when journalists get sued. OCCRP has mentioned they were able to not allow the lawsuit to kill the story. This has been an approach applied in the killings of journalists, such as forbidden stories. When there's a lawsuit of this nature, journalists should have the resources to double down as a deterrent to these kinds of frivolous lawsuits. Anti-SLAPP laws are obviously being explored in the UK and Europe. In the US, also just to mention, according to the Institute for Free Speech, 19 US states have no anti-SLAPP laws, and another 12 to 15 get low grades. So there's work being done, fortunately, in Europe and the UK, and more work still to be done in the US as well. Training, of course, training for journalists on how to handle these legal matters, training for judges on how to understand the international frameworks for freedom of expression. I think legislative changes frequently take too long. And I think one of the things that I feel like has come across today is that there are a number of measures in the arsenal that don't require massive legislative changes, things that can be done quicker, including innovations like this insurance scheme to get journalists the resources they need to defend themselves. Have I missed anything? I'll let the panelists jump in. Have I missed anything for your, and from your vantage point, guys, which of these measures do you think is most valuable right now? Where do you want to see more and greater effort?
If I may just respond to a couple of questions, Nick, that came up.
Great.
So a question, what countries will the insurance program cover? The goal is to cover as many countries as possible. Certainly we want to cover the United States and the UK, where the threats are greatest in terms of frequency and also cost. But lawsuits happen everywhere. There are some regulatory issues because we have to confirm that we're not licensed to sell insurance in every country, and we're working on that issue. It's a little more complicated than it sounds. And then another question, would this insurance program help with pre-publication legal review? And the idea is that yes, it absolutely would. One way that we can keep the costs of paying off insurance down would be to require policyholders to submit their articles for pre-publication review by lawyers so that the lawyers could help to reduce the risks of lawsuits. So we intend to build on an existing network of lawyers we have around the world to be available to review articles before publication. That's a couple of questions. I don't want to hog the microphone though.
If I can, Nick, just, one of the things that I'm not sure people realize is that, if you're operating, as an investigative reporting organization in most of the world, you probably don't have insurance. Most of these organizations are uninsurable right now, and that's a serious problem. And the way the system works now is you get sued, you get into a lot of trouble, and then you go around with your hat out asking for people to help bail you out. And there's a lot of great organizations out there that help and provide money, but it's difficult as an editor to really plan. And so really the way the system works now, it's an incentive to self-censor yourself when you get involved with really difficult cases. And there are people out there who sue almost every single time. I mean, it's the Sheldon Adelson kind of personality out there that are going to continuously, Aaron Banks, these people will sue, and there's really very little you can do to stop them. And so consequently, you're going to be sued, and therefore you self-censor. And that's what we really need to get away from.
If I could just follow up on that, I just wanted to mention about, we've seen examples of journalists going public with letters that they have received. And sometimes that, has stopped anything, further, and it's just shown it for the kind of chancing opportunity that it was. I mean, we would definitely, get things checked by lawyers, but if safe to do so, we would encourage people to publish them as a form, or publish the fact that they've received this threat as part of their reporting. because it draws attention, it draws spotlight. I think a lot of the success of these letters, particularly from UK law firms, is they go out, all stamped private and confidential, not for publication, and the whole process is just hidden. And I think, picking up on Alex's point as well, it's like a sign of solidarity too, to make sure that there is reporting about these cases. When I first spoke to Paul Radu about the OCCRP case, I noticed there was no media coverage at all. And I asked if that was a strategy, and he said, no, not really, just there wasn't, media covering it. Contrast that with Catherine Belton and Tom Burgess's case, two authors and journalists who've been sued here in the last year. And I'm really pleased to say that we've seen a lot more outcry. Both of those cases are now, concluded, but and in their kind of favor. But definitely reporting about it, also to NGOs who can put them on media alert platforms, as well as regulatory bodies. I know there's a lot of journalists who've been dissatisfied with the Solicitors Regulatory Authority if they have made complaints in the past. But for the first time now, they have updated their guidance to include reference to SLAPs here in the UK. And I think, like with the consultation, there is an opportunity to really provide strong evidence on it. So if you have those kind of things, do submit them. It is worth doing. I know when you're dealing with legal threats, it might be the last thing you really want to. But yeah, being prepared as well, kind of with resources, if there's funders in the room to kind of educate people, so that these letters, especially if you're not in the UK and you get a letter from a UK law firm, it's not a completely overwhelming, shock to the system, and you can be put in contact with people like Alex who can provide, that initial support right away.
And let me just jump in, Susan. You're absolutely right, of course.
Alex, I just want to, Alex, if you don't, let me just give
No,
Sarah
please.
one chance. Yeah,
No,
let's
please.
give Sarah one chance to jump in before we carry on. Sarah, did you want an opportunity to remark on the solutions to this? Hearing about the insurance scheme, the anti-SLAPP laws, and other efforts to try and resource organizations such as Ojo Publico better. Any final remarks from you on where you think we can invest our collective energies?
Well, I think that it's very important to work as a body, no? I think that it's not it's not working that we have a network of lawyers reviewing the journalistic work before the publication, no? But I think that it's to have a firm of lawyers, or to have this insurance that could help us if there's any lawsuit, any defamation, definitely something that could help us. I hope that Ojo Publico don't have a high rate for that.
It sounds like they're working on it. We'll be curious to see what the premiums look like as well, Sarah. So look, Alex, I'll open up the floor again just to read a couple of questions that are coming in. A question on whether there might be some solutions for independent freelance type journalists or bloggers who aren't a part of news outlets. How do we help them to defend themselves? And also some questions, a question for Alex, Susan, or Drew on how they see the EU directive to combat SLAPPs, if it will be successful, if it could be expanded to include EU candidate countries in the Balkans. I'll stop there. There's a couple more coming in, but I'll give Alex, do you want to jump back in? And anyone else who'd like to answer those questions, go ahead.
Sure. So one thing to know is that the threatening letters are used as a way to block journalism, not just through intimidation, but literally from closing off sources. So as a journalist, you want to go to the subject of your story and get the comment on what you're writing. You really have to do that. You go and you ask the question of the subject, and the subject hires a lawyer, and the lawyer writes to you and threatens you and denies everything, and then says that this letter can't be published. And you as the journalist are paralyzed. You can't use the letter to provide the comment from the subject. You're under threat from the law firm. And this happens all the time. And so Susan's point about publishing the letter is an important one. Now you have to be somewhat careful with that. It is a good idea to ask a lawyer about it. There are lawyers available. I am, Susan is, and others as well. But you really have to understand that this mechanism of threatening letters is a way to keep you from writing in the first place. to the issue of whether you can perform journalism if you're not, if you're an independent journalist or a blogger, absolutely. You don't have to be certified as a journalist to publish. And we have cases, many cases of individuals through their own blogs or Facebook posts or whatever who are providing news and information to the public. That's journalism. You are a journalist if you are providing news and information to the public, news and information of public interest, right?
But they're often not covered though by insurance systems. There are some freelance systems organizations like FIRE offers some policies that's independent investigative freelance investigative reporters. And I think they're the main one that I know, but there are some, possibly SBJ, possibly Rory Peck, some other organizations offer these. You have to look it up. But the reality is that insurance often is not particularly expansive. It doesn't handle a case in London, possibly. And to be honest, if you're a freelancer or a blogger trying to do investigative work, it's a really, really difficult environment. And I'm not sure how many are going to really be able to survive the kind of problems that we're going through. But there are some insurances out there.
One place to look, not for media insurance, not for protection of defamation, but for other harms or risks that a journalist faces, is ACOS Alliance. A Culture of Safety Alliance has offerings of insurance products, particularly for journalists who are going to conflict zones for their reporting. To the issue of the EU, there is a working group developing potentially a rule on an anti-SLAPP rule, but that is not yet done. I'm a member of that working group, and there are ongoing meetings and discussions, but there is not yet a rule from the EU on anti-SLAPP.
And with regard to whether that might be directed in some way, extended to the Balkan and EU candidate countries, do you have any information on that, Alex?
Well, I would just say that would depend on the governments of those countries adopting that EU directive. It wouldn't apply in those countries by virtue of the EU's decision. Now, a journalist from another country outside of the EU would have those protections, presumably with respect to any action in an EU country. So if you're a Bosnian journalist and it's a German person who is threatening to sue you, you presumably would have the benefit of some EU protection. But if it's another Bosnian who's threatening to sue you in Bosnia, that EU protection would apply only if Bosnia has adopted it as its own rule.
Great, thanks, Alex. But there's two related questions that have come up that are really excellent. So David Keating from the Institute for Free Speech asks if any nations have passed anti-SLAPP laws that are well written or exemplary in your view. And Barrister Akonte Clifford from the Central African Republic also asks if you guys have any recommendations for countries that have successfully pushed back against politically motivated laws to suppress freedom of expression. So a specific question on an exemplary anti-SLAPP law, and a broader but excellent question on whether there's an example we can look to for how to move the needle on the legal enabling environment for journalism. Any thoughts, guys?
Well, the classic anti-SLAPP law is the First Amendment in the United States. Not to be facetious, but it is much stronger protection for publication than pretty much anything else in the world that I've heard of. And then within the United States, as I think Nick said, there are many states that have enacted anti-SLAPP laws that work really quite well. California, New York have those laws, but other states do not. I believe, for example, Florida does not have anti-SLAPP law. So in the US, of course, it's always tricky because you've got 50 states to worry about.
And to Barrister's argument, I mean, I think all over the world, there's amazing work being done by activists and journalists, fighting these kind of efforts to handcuff the media. Recently in Bulgaria, there was an example of a quasi-democratic government getting elected after years of a repressive, anti-media government. And in Central Asia, there's a number of fights going on right now, between media and other countries. And this is just an ongoing fight in many countries around the world, and it ebbs and flows. Unfortunately, autocratic power, tends to get stronger over time. We're losing probably more than we're winning. But there are some excellent examples of reporters in India, they're fighting the government there, all over the world, or there's Russia, even though they lost recently, a number of media have left Russia and they're now fighting from abroad, as expat media. So, it's going to go on for a long time, and we're going to win some and we're going to lose some. But what it really comes down to is the commitment of the media to continue to tell the story in those countries. And that's up to the individual journalists and the network of journalists to support each other and continue fighting on these issues and not give up.
To add to what Drew is saying, look, there are examples of successful media sector reforms out there, like, are partially successful in many cases. Ukraine and Tunisia come to mind. The Gambia more recently, I think, ended criminal defamation laws. But I think there's a broader point here, which is that much of the progress that's been made has been done in regional international solidarity. The push against anti-defamation laws, had a lot of international support that has lost some steam. And I think to your point, Barrister Clifford, I think the Media Freedom Coalition and some of the growing interest at the political level in media freedom could be very usefully directed at creating that international pressure to get those kinds of laws off the books. I think that's where I would look now for support. Susan, you wanted to come in on that? There's one more question too from.
I know we're very short time, but I noticed there was a question in the chat regarding whether SLAPP suits were used in coordination with disinformation campaigns and online abuse. And I'd say that we've come across several, if not numerous cases where journalists who are subject to legal threats are also facing smear campaigns, on and offline surveillance, and online trolling. I mean, Cadwallader, who I mentioned earlier, has been the subject of an immense amount of online trolling, which kind of flares up every time there's a development in the case against Aaron Banks, and particularly when she had to drop the truth defense because of the single meaning decided by the judge, which I mentioned earlier. There was a lot of trolling which made it sound like she didn't believe in her own reporting, rather than the understanding of the nuance of why she had to just stick with public interest, which was her defense she took to trial in January. So, what you were saying there, Nick, about, the Media Freedom Coalition and all these kind of groups defending media and national action plans and things coming, we really need to make sure that legal threats and legal challenges are squarely, up front and center, because they are important of themselves, but they also connect to so many other violations related to media freedom. So I think that's what we really need to see now, as a recognition that legal threats are a form of very serious violations against media, and they feed into, we actually only really in Europe started working on them so much after the assassination of Daphne Caruana Galicia, who you mentioned earlier, because it was so shocking to discover just how many legal threats she was under at the time. So I hope now, people who are working in different areas listening to this will push for that recognition.
But that's a great note to finish on, Susan. I think there's a couple of pending questions to quickly answer. One question about how long to wait for this insurance scheme. In 2 words, Alex or Drew?
A year.
1 year. Great. Another question in the chat about who to turn to in Africa. Who are the leading lights of African networks on legal freedom of expression? Pan-African Lawyers Union, Media Foundation for West Africa, all of Article 19's excellent offices across Africa. I'm sure I'm missing many, but just to name a few. But those are the last pending questions. You're welcome to be in touch with us at CIMA with any outstanding questions, and we will direct them to the panelists or to someone else. Look, just wanted to thank our really terrific panelists, Sarah, Susan, Alex, and Drew, for being here today. Thank you for your excellent and innovative work in defense of freedom of expression, for your courageous work, Sarah and Drew. And thanks to Andrea, Vega at CIMA for bringing us all together today. We hope to carry on this conversation, and we look forward to being in touch with all of you again later this year. So thanks very much, everybody. Have a terrific day or evening.
Thank you.
Thank you.
Thank you.